Tapes rolling. Coming to Peggy in 3.
From Facebook to Twitter, criminal investigators and the courts are taking a stand against the use of social media by prosecutors, defenders, and jurors. Joining me with a look are David Danielson, presiding judge at San Diego Superior Court, and attorney Alex Simpson, adjunct professor at California Western School of Law. Welcome to Evening Edition.
Thank you.
Judge Danielson, what are you seeing in terms of the use of smartphones, iPads, or tablets in the courtroom?
Well, they're everywhere. I think everybody who comes to the court has got one. And the question is are they compatible with being in a courthouse and doing the things that you're supposed to do in a courthouse?
Well, I know that you've handed out a poster that we've got a picture of we can show. You handed out, and it's also on 8x11s to jurors. My question is, can each judge decide how electronic devices can be used in his or her court, or is this sort of the gold standard?
Well, there are really two issues. The first is what can a juror do to broadcast information about what's going on? What can they do to get research information? The second issue is, if you were to have a notebook and a pencil, would a judge allow that? If you're using your iPad as a notebook, perhaps a judge could. But judges can't authorize, and state statutes prohibit jurors from doing any independent research when they're on a jury.
And we're going to come back to that because it's an important issue. But Alex, first I wanted to ask you, I know I've seen reports of people tweeting that they've committed a crime or posting on their Facebook, say, a picture of them drinking and then being arrested for a DUI. Can any of that be used in court as evidence?
Yeah, I think there's no real difference between the type of information that you'd see in social media and the more kind of traditional information that you get in a regular trial. Somebody confesses to another person, the person who heard the confession can get up and testify that they heard the confession. Social media is not really different in that sense. You send something saying, I've committed this crime, that information can be used against you.
And Judge Danielson, what about the right to privacy? What is the expectation of privacy if you're on social media?
Well, one of the key critical elements of deciding whether something is private or not in a legal sense is whether there is a reasonable expectation of privacy. So if people do have information in a location, in their home, for example, that is private, there are protections. But when you start broadcasting it out into the world, so if you post it on social media, one has to question, do you really have any expectation of privacy? Even though you think there are some privacy settings, I think we know now that most of this stuff is available.
And on the other side of that, Alex, in high-profile cases, I understand that attorneys, they want to find out as much as possible about the jurors or potential jurors. Does that mean that, let's say, an attorney can search a juror out or seek out a sort of the juror's social media footprint?
Yeah, the vast majority of cases, you wouldn't really even have time to kind of look past the juror that's sitting in the box to find out whether or not, they have something on social media that would be helpful to determine whether your case is a winner. But obviously, high-profile cases means there's more time, there's more energy, there's more money that's involved, and so that can be a valuable tool to find out something about a juror that maybe they're not really going to be forthcoming about while they're sitting in front of you.
And Judge Danielson, I do want to wrap up with this because it is so important. Why is it important for a juror? We've heard the instructions before not to do online research. Let's say they don't understand a word during testimony, or to post anything about the trial via social media.
The basic underpinnings of a fair trial have to do with jurors and judges hearing the evidence that's been filtered through all the formal, standardized processes of the court proceeding. Otherwise, if we let jurors go out and read books, go out and use the internet, go out and read newspapers, that sort of thing, I think, have just authorized a scavenger hunt for the truth rather than a formal standard procedure.
So do you think that social media will force us to maybe change these standards and allow for this extraneous, or do you see that not happening?
I don't see that happening. I think every technological change will be anticipated, dealt with under the same old rules. We just simply have to warn people that now that you have this new option, the same rules apply and you're still limited.
All right, we are out of time. San Diego Superior Court presiding judge David Danielson and law professor and attorney Alex Simpson. Thank you.
Thank you.
Thank you.